Good morning. My name is Nicole Sommer. I am a planning and environment lawyer working at Dobson Mitchell Allport here in Hobart. I am a environmental impact assessment specialist, if you like. I have worked in New South Wales, Victoria, Tasmania on a whole range of different projects and EIA processes. And so I've been asked to help take you through EIA at the local council level this week. So hopefully I can provide you with some different insights from someone who practices here in Tasmania all the time. I do this on a day-to-day basis, and so hopefully that will provide you with some good insight. In this lecture, I hope to take you through really a very brief overview into different EIA processes in Tasmania. I'm going to briefly touch on the role of local councils versus the EPA, but really I will focus on the role of local councils given the short time frame and because I know that Danielle McPhail will take you through the EPA process in some better detail in a few weeks. I'm going to look at EIA required by planning schemes, so what is the scope of the EIA required, content and responsibilities, and in doing that I'm going to look at specialist reports, which will hopefully help you with your upcoming assignment. Why are they required and how do you manage them? I want to take you through a case study to illustrate the standard form of EIA at the council level and the role of councils and role of specialist reports. I'm using quite a controversial development on the east coast of Tasmania. It's been in the local news, the Cambria estate at Swansea. The developer wants to build a new golf course resort with 150 rooms, health retreat and accommodation. It's right near the Freycinet Peninsula and it has been very controversial. In going through my lecture, I want you to imagine that you're a consultant acting for the developer of Cambria Estate. You're briefed to apply for a planning permit and you need to project manage the approval. The site that we're looking at here is over 3,000 hectares and it has multiple environmental constraints. There's heavily vegetated areas, some containing listed threatened vegetation communities like eucalyptus and Magdalena on sediments, and temperate coastal salt marsh, which is an EPBC Act Commonwealth listed threatened ecological community. As you would expect, part of the site is in a scenic landscape corridor along the Tasman Highway with views to the hazards at Freycinet Peninsula. Part of it is a narrow strip between the settlement of Dolphin Sands and Malting Lagoon. Malting Lagoon is an internationally protected Ramsar wetland and home to migratory wader species. The site includes significant agricultural land, hilly rocky areas of landslip, which is further to the west in that yellow area you can see on the screen. And there's multiple creeks and rivulets running from the hills into the wetland. There's 2 heritage areas as well. No doubt there will be Aboriginal heritage values on the site which are unknown. And this site, because it's outside a settlement boundary, is not connected to reticulated water or sewage, so all water must be brought in and sewage treated on site. So this lecture will help guide you through how to navigate the approvals required, working with local council in an EIA process and engaging specialist experts for the project. So what are EIA approval processes in Tasmania? Well, I've listed them all here on the screen, but I just want to be clear that all EIA approvals in Tassie start with a planning permit application made to the local council. So that's your starting point. You need to be comfortable with the planning permit application process if you're doing EIA. There's a range of facilitation legislation, if you like, which I call the 1%. Very few projects go through that sort of process. 99% of process go through a discretionary planning permit application. You might need a rezoning application if the use is prohibited in the zone, which is the case for Cambria, but we won't touch on that very much here today. perhaps we can deal with some of those questions that you might have about that process online. And there are a proportion which are level 2 activities assessed by the EPA. So step 1 is what process do you need to follow for this project? I want to say up front, I am a lawyer, but always be aware of what the law requires, because the law informs the reports needed and the scope and constraints around the development. So the primary approvals that you will require here really is the planning permit that you obtain from the local council as the planning authority under the Land Use Planning and Approvals Act. I won't go through this in detail, but I have provided you with links to where you can obtain more information about the process and about the legislation. So to determine what the approvals are that you might need, so how do you work out what form of EIA you might require? Well, my view is that you have to understand in great detail what is actually proposed. What is the activity? Here we're looking at a resort, a golf course and accommodation in 3 precincts. It's also an aged care facility called a health retreat. So there's a lot of people coming onto the land to live or to stay. Those are the sorts of things that you need to think about. So in understanding what kind of EIA is then required, you need to understand what sort of impacts might occur from that activity. Here, my feeling and understanding from reading the report is that the clearing of native vegetation is probably a key impact. So you'll need to clear land in order to develop it. There's the 2 heritage areas, and impacts to those heritage areas will be relevant. Proximity to the Ramsar wetland, runoff and migratory shorebird impacts. So proximity to the Ramsar wetland and migratory shorebirds might be an issue for runoff or for any development itself. There's also the need to dispose of sewage on site, so you'd need to understand how sewage will be disposed of. It's actually a very important issue, particularly where there's a low-lying coastal area and where there's landslip. Then of course there's the view corridor to the hazards, which you can see here in this photograph, standing on top of that Western Hills area of the site, looking over to the hazards, and there's a significant landscape issue there to be considered. But does that make it a level 2 activity for the purposes of the the Environmental Management and Pollution Control Act, regulated by the EPA? Well, that's the first question you've got to ask. If it is not, then the second question is whether the use is prohibited in the zone. If it is, you'll need to do a planning scheme amendment, and that's in fact what's proposed for the Canberra proposal. But if the use is not prohibited in the zone, then you just go through the council planning permit process. And I've provided a link on this particular page to the Schedule 2, which lists what a Level 2 activity is. Again, Danielle will take you through that in the next couple of weeks. But as a starting overall point, what is a Level 2 activity? Think about it in terms of pollution. So here we're talking about things that pollute land, air and water. The impacts are really about noise, about contamination, so things like noise from wind turbines or quarries, and water pollution from finfish farming. I've called quarrying rock farming. That's not a technical term. I just think that that's how you should look at it. These are all polluting activities, and that is what requires EPA assessment. There are, of course, a range of other environmental impacts, but they don't necessarily trigger an EPA assessment. So things like resort development, and here's a resort development proposed for 7 Mile Beach, might require extensive clearing. But that doesn't mean that it is necessarily an EPA assessed activity. In fact, it won't be. Land clearing in swift parrot habitat doesn't trigger EPA assessment, for instance. So environmental impact per se does not equate to EPA assessment. So you need to understand the difference between pollution and other impacts. Other impacts are assessed by council ordinarily through a planning permit application. So the next step is to work out what information is needed for the permit application. And to do that, you really need to know what zones and codes are triggered. You need to go back to the planning scheme, because at a council assessment level, the scope of EIA is constrained by the planning scheme, and that also constrains the reports required for any approval. A council who is assessing a permit application can only consider the applicable standards triggered by the planning scheme. So those applicable standards are set out in the zones and the codes. You need to go back to those and and be very comfortable with what is triggered and what is not. Council have little, if no, scope to ask for information beyond what is triggered in the planning scheme. So as you go through this course, you'll see that the EPA will effectively scope what is required for its assessment, and the officer assessing the application tells the proponent what information is required. But for a planning permit application assessed by the council, the scope is driven purely by the planning scheme. So it's really important to understand how these things are triggered, and a really great starting point is the list. I'm just going to try and take you through the site. So there's 2 townships. The site is what I am currently drawing a line around with my cursor. And just to zoom in a little bit more, you can see here that I've got the overlays on, and there's a heritage area. The zoning is rural resource. And all of those squiggly lines represent different codes. So the overlays are waterway and coastal protection area, coastal inundation hazard area, potential acid sulfate soils, and biodiversity protection area. Each of those will trigger a different assessment under a different or the same code, but they'll tell you that that's an applicable standard. So again, look how big that heritage area is. And that area to the right that's in blue, you can see is the Ramsar wetland. So this is all part of the site. And there's significant values in this area. Moving further to the west to the hills area, which is where the proposed resort is, you can sort of see the topography, but importantly, you can see that there's a large area of biodiversity protection area mapped here for lowland grassland complex. Again, there's another heritage area, and scattered throughout in the rocky hills are landslide areas. So again, there's another biodiversity protection area, eucalyptus, pulchella, forest and woodland. And this really tells you that there's a lot of different things going on this land that you need to be aware of. The green that you can see on the list is the road corridor, which is mapped for a significant landscape. So significant landscape overlay is also triggered. And in this way, you can start to see what some of the issues are for this particular proposal. So that brings you really to what specialists you need to brief, even before you lodge the planning permit application. You'll need to think about what information you need to provide to the council to help explain the proposal or to demonstrate that the zone or code applicable standards are met. The scheme will not necessarily tell you those things, but it's a really good starting point. You also need to brief specialists to scope a development application as a starting point. So it's really important as a first principle to get out onto the site and look around. Take your experts. If the site is vegetated, take a flora expert, take a traffic expert, take your geotechnical engineer. It's good to have all of the relevant information to hand before you submit the application, so you're not briefing new experts or conducting new investigations partway through the assessment process. That just causes delay, and if you're acting for the developer, that'll be a big problem. And as the project manager, you're expected to be on top of all aspects of the site and the development and all impacts. So think about what's needed to understand the development at first principles. So think about traffic, for instance. A traffic impact assessment is almost always required with a permit application. You need to work out how the development will fit with the surrounding traffic network and how on-site access and parking will work. There are Australian standards to be met, which you may not know about. So you, as the EIA expert, architect or planner, may have a great idea about internal road layouts, only to find them you can't get them approved, or the buildings are in the wrong place to allow that sort of access. So you need to think about that up front. Of course, then there's the reports that are required by the legislation, so by a code in the planning scheme, or required by the regulator itself, so by the council, as further information. There's another subset of reports that you might submit with an application, which are those that are advisable to obtain approvals. So every application will have a planning report submitted with it by a qualified town planner, which is not required by the scheme. There are others reports that won't be required by the scheme, but will be helpful to explain to the council what the impacts are. So you need to think about those separately. As an example of requirements of the scheme itself, I just want to give you a demonstration here of the Biodiversity Code. So there'll be application requirements in each of the codes, and they may tell you what you need to submit. So here, the planning authority may require the applicant to provide a natural values determination. In addition, if you look at E10.5.2, you might be required to provide some other form of report. Those types of reports and the scope of those reports are then defined back up in the definitions section. So it tells you what a natural values assessment is. It's an assessment undertaken by a suitably qualified person. A suitably qualified person is also defined. So it tells you who it is that you need to engage in the planning scheme itself. So now you're ready to submit the permit application to the council. You'll submit it to the council as the planning authority, and the council planning staff will assess the permit application. I've provided you with a general layout here for people who aren't familiar with the planning system, but be aware that council planners can and most likely will ask you for further information under Section 54 of the LUPA Act. Any information request will stop the clock for the statutory timeframe, and you'll need to satisfy the council planners that you've provided all the information required before they'll keep assessing the application. So the application will only get advertised and then a decision made if the council planner is satisfied that the information is sufficient. Be aware that in information requirements, the council planner cannot require you to submit information about something that's not triggered under a relevant zone or code. For instance, Aboriginal cultural heritage can never be an information requirement because it's not triggered under any zone or code. Think also about what might be exempt from planning permit requirements. So the Biodiversity Code might be triggered, but it may not require a permit because there are no significant values. That might be what your report is trying to demonstrate to the council. There's a range of other things that might not be relevant. For instance, the proximity of the township might not be relevant. The impact of odour or noise on the neighbouring use in the village zone in Dolphin Sands may not be relevant. Have a think about those things. Once you've submitted all of your reports to the council and they're satisfied with them, the council will give public notice. Public notice is a really important part of environmental impact assessment. It's a fundamental principle of it, in fact, because there's an idea that public participation in environmental decision making results in better decisions. So this public notice requirement gives people an opportunity to make a representation about the proposal. So any person can make a representation. They don't have to be the neighbour, they don't have to be affected. It can be an environmental group, it could be someone living in Burnie for East Coast development. But the representation must be relevant to the application and also to the planning scheme requirements. Usually people make representations themselves, but you could be engaged as a consultant to prepare a representation on behalf of someone else, or you might engage a planning lawyer like me. I draft representations all the time. You must be aware of the representation period. You have to file it within that 14-day period or the time specified in the notice, and it won't be accepted if you don't. That's really important because you can only appeal if you're a representor who's made a representation within that statutory period. So it's actually a very important part of the public participation process. I've said here that sometimes after the public notice period has ended, the council officer might come back to the applicant with matters that are raised in representations or to ask the applicant about permit conditions. But that doesn't happen all the time. There's no requirement under the Act, and in fact the council has a very strict statutory time frame. So be aware that may or may not happen. Then we get to the council decision. So the council planning officer is responsible for assessing the application, and they write a report to the council recommending refusal or recommending approval with conditions. Sometimes the council officers might make that decision themselves, but where there are representations, usually if it's 2 or more, it will go to a council meeting. And be very aware that the council can make a different decision to the recommendation of the council planner. It is really here at the council meeting, the council approval stage, that the decision is made. And remember that the aldermen who are making that decision are democratically elected as representatives of the community. They listen to what people say to them about the proposal. Nevertheless, they are constrained to make a relevant decision, one that's open to them under the planning scheme. So they have to, if they're going to refuse it, it has to be on a planning ground. Final step is usually an appeal to RAMPAT. If you're very unlucky, you'll end up in the Resource Management and Planning Appeal Tribunal. And this is usually because one of two things have happened. The council has refused the application and you're acting for the developer, you advise your client to appeal, or you might appeal certain conditions. Or a third party, someone who's made a representation, has lodged an appeal. Now, the RAMPAT does not often have Tasmanian devils in it, and we don't wear wigs like in this picture here, but it is a formal legal process. Usually you need to engage lawyers, and your experts who have prepared the specialist reports will most likely need to give evidence and be cross-examined by other lawyers. So it can be a very confronting process. It's potentially very expensive, and costs can be awarded if you don't substantiate your part of the appeal. But remember that the appeal process is part of EIA. Public participation in environmental decision making, as I've said, is a principle of ecologically sustainable development and the EIA process. And that includes third-party appeal rights or the right to a fair hearing. Remember that there is no other part in this council process that allows someone who opposes a development, environment group or a neighbour to test the evidence that's been put forward by the applicant or to have a hearing in person. So once you get to RAMPAT, there'll be a hearing, people have to file evidence, and you test the evidence that's filed on the part of each side. It's also an important aspect from the developer's point of view, because if the council refuses the application having listened to the community, this might be the only circuit breaker that you have. So while developers might see it as costly and time wasting, RAMPAT is there to provide a fair hearing both to members of the public and to developers. So it is actually a very important process, and that's why I've raised it as part of the EIA at the council level. So that ends the council assessment process, but I did want to just touch on planning scheme amendment processes, because often controversial developments will go through this process instead of the usual DA process through the council. I'm not going to deal with it in any detail, but just think about the fact that a planning scheme amendment is assessed by the Tasmanian Planning Commission, and they make the ultimate decision, not the council. And planning scheme amendments have different tests and a broader scope. So you can see here that there's a broader range of things to be considered, regard to the impact that the use and development will have on the region as an entity, conflict between land uses, and consistency with the regional land use strategy that applies. You also need to consider the state policies under the State Policies and Projects Act. This is the only time that they're relevant. They're irrelevant under the planning scheme, and I'm not going to go into them in detail for that reason. But there are state policies which set out what should be considered when you're going through a planning scheme amendment process for environmental assessment. And these are the 3 policies that have been made. So there is a broader assessment here if you're going through that process. So let's just move on to briefing specialists and some tips that I have for you as someone who's practiced in this area for a while. Just be aware that the project manager role usually falls to the planner, so it's really critical for you to understand when you need specialist advice, and it's your job to advise the client about what money to spend on what consultants and why. You're the one who needs to think about the instructions given to each expert and the timing of the report. Why is the report required? It might be required for scoping of the development itself, to identify what constraints are limiting. Bushfire is a classic example. You're probably going to need a bushfire report and maybe an ecological report or a natural values assessment up front. Reports can also refine potential impacts, so reports can help you avoid, minimise and mitigate those impacts by altering the development. If the report is required by the regulator, you'll need to understand the regulatory requirement in designing the development as well. You might want to wait for a request for information, but you really need to understand what the scheme provision is attempting to ask up front. As I say, don't wait for later to wait for the information request, because you may have delay, or it may alter the development as a whole if you don't know about an impact when you're designing the development. Finally, it's really important to understand that reports are going to be relied on throughout the public process, by the public, by the regulator, and ultimately the decision maker. So accuracy and legitimacy of those reports is critical. That includes who you're actually engaging to prepare the report. Also, when we get to the appeal process, that report will be tested in a much more formal manner. So it's really important to get that right up front. And finally, I wanted to say one thing, which is to be aware that there's a whole range of other approvals that might be required, what I might call secondary approvals, which might also constrain your development. And those approvals are worth considering up front. I've listed some of them there. This is not a complete list, but it's a pretty good starting point for people who are unfamiliar with the process. I'm happy to take any questions about that online. So thanks for your time. I hope this has been a useful exercise, and I will be answering questions through Milo, so feel free to ask any further questions. Thanks.